Okay, welcome back, everyone. I'm sorry we had to cut short the World Cafe. I think it became a bit of a global cafe outside, those of us who are having coffee outside. Number of things to start with. Firstly, sadly, I'm not Jess Gavron, who you can see up there. Jess would have loved to have been here. For family reasons, she can't be here, so she sends her apologies and her best wishes. So I'm deputising for Jess, who is, I'm sure many of you know, legal director at ECtHR. And as you can see, we've decided, as it's late in the afternoon, we've decided to sit down and we're going to kick back and try and have a bit of discussion. And we're turning, as if things haven't been difficult enough already, to talk about implementation in three very challenging states: Azerbaijan, Russia, and Turkey. And we've got a fabulous panel of speakers who've all been involved in different ways in cases and issues from those three countries. And we have joining us online Anna Mahmadli, who's going to be our first speaker. Welcome, Anna. Can I just check you can hear me okay? Excellent. Great. I'm going to introduce all the speakers just briefly to start with, and we're going to kick off with Anna and then Ramute, who will talk about Azerbaijan, and then we'll turn to Russia and Turkey. Anna Mahmadli is the chair of the Election and Monitoring and Democracy Studies Center in Baku. Ramute Remazaiti, to my right, as you've already heard, is EIN board member and has also been involved in many of the seminal cases from Azerbaijan from the European Court in recent years. Then we'll turn to Russia. Elba Bendo, to my left, is a lawyer, another lawyer at the European Human Rights Advocacy Center, and to Dmitry Gurin, who is senior lawyer at Memorial, and we'll focus on Russia. And then last, of course, but not least, Turkey, and Kerem Altıparmak, who is as many of you will know him as a very experienced practicing lawyer in Turkey and also representing the International Commission of Jurists. And what we're going to do is have relatively short submissions from interventions from our speakers, sort of 5 minutes or so each. And we've asked them all to talk about the challenges that they face in these very, very difficult contexts and some of the strategies that they've adopted in dealing with those challenges. So that's what we'll focus on for the first 5 minutes or so. I'm going to start, Anna, with you, and then we'll have a quick round of recommendations, sort of top-level recommendations that they would make, before we then open out and have a bit of a discussion and an argument, maybe, hopefully, with the audience. So without further ado, I'm going to hand the floor to Anna to talk about challenges and strategies in Azerbaijan. Anna, you're very welcome. Thanks for joining us.
Thank you. Hi, everybody. I am sorry that I can't join you in person today for some technical reasons. But it is a great honor for me to be part of this discussion today. So, implementation of European Court human rights judgments on Azerbaijan has been problematic since the first judgment that came into force in 2004. And execution problems are related always on both issues, individual and general measures. So right now, more than 230 decisions on Azerbaijan are pending for implementation. So among these, the cases, there are approximately 45 leading, and remaining are cases repetitive. So what is the problem for implementation of the judgments? Actually, our past 17 years of experience shows that Azerbaijan government doesn't have a political will for implementation of the Court human rights judgments and improvement of national legislation in order to European Convention, Despite regular calls by Committee of Ministers of Council of Europe, discussion on group cases periodically, and some resolutions about the Azerbaijan or about the cases, the Azerbaijan government has not provided any necessary information on individual or mostly in general measures issue. For example, government regularly notes that amendment to the number of articles to national legislation, including Code of Criminal Procedures, were made to bring domestic law into compliance with the Convention and case law of European Court. However, such amendments do not reflect any recent developments, any progress in the legislation, and to prevent misuse of the criminal law, and fail to demonstrate will of authority to adjust domestic legislation according to calls of the Committee of Ministers. So I also wanted briefly to talk about the role of civil society groups, and as you mentioned, some challenges facing civil society groups. The participation of Azerbaijan civil society organization in the implementation of the European Court of Human Rights decision can be divided into two periods. First period lasted between 2007 and 2013, and second period started after 2014. So in the first period, civil society organization in past had some opportunity to conduct a national advocacy campaign, organize various discussions, establish a dialogue with the members of the parliament, representative of the government. So in such discussion, it was possible to bring into national-wide discussion of European Court of Human Rights decision and document of the Committee of Ministers. So we referred always as a powerful documents as a civil society groups for promotion of human rights and freedoms and rule of law in Azerbaijan. But after crackdown, which started in 2013 on local and international NGOs and on media, especially arrest of the human rights defenders, politically motivated criminal cases against the independent NGOs, and adoption of the repressive norms on freedom of association, significantly change the space and the restricted space for civil society groups. So last 6 years, local NGOs only were able to attend some kind of activities for increasing national control over the implementation of the European Court of Human Rights, the decision and the resolution of the Committee of Ministers. So we were able to submit our documents under Rule 9(2) regulation, advocating on media, but there is a limited space right now for our activity. So in this proposal, we think that one of the most important steps should be for Azerbaijan case to lift all these bans, all these restrictions, and actually Azerbaijan government should improve domestic legislation regulating operation of the local and international NGOs, and safeguard and guarantee for freedom of expression and freedom of assembly in Azerbaijan. So legislation for operation of NGOs should be changed. Some free space for civil society organizations should be restored. Otherwise, it is difficult in such a circumstance to be part of this process and be part of, for example, advocacy process, and to talk about non-implementation of the European Court of Human Rights judgments in Azerbaijan. So, and that's why we're trying to raise in front of Committee of Ministers that right now, for Azerbaijan, the civil society organization, it is important to engage this process with legal guarantee, without any political repression, any political prosecution. So this is just my short briefing for Azerbaijan, but I think during discussion we will get some opportunity to share our recommendation on this topic. Thank you very much.
Thank you very much, and I will come back to you, as I say, with some brief recommendations shortly. First, before I go to Ramute, an apology from me. I told you who I wasn't. I didn't tell you who I was. Being not just Discover, I'm Philip Leach. I didn't introduce myself. I'm sorry. I'm Philip Leach. I'm from Middlesex University in London. Right.
Nice to meet you.
Let's go to Ramute, who, as I said, has been working for ERAC. So Ramute has been deeply involved in much of the litigation, working for ERAC with, sadly, not really with NGOs in Azerbaijan, but with individual lawyers in Azerbaijan. So we turn to Ramute and challenges and strategies, Ramute.
Thank you, Phil. So following on some very helpful but deeply concerning comments and remarks from Anar, I would like to say a few more words on the lessons to be shared on the issue on implementation of European Court judgments in the cases that Iraq has litigated together with our partners, individual partners in the country, against Azerbaijan. I will primarily focus on our experience with regard to the cases of human rights defenders and NGOs, which have been effectively paralyzed following the crackdown that Anar had mentioned. And this touches upon the issues not only that are relevant for Azerbaijani context, but I think it concerns issues that are also deeply concerning with regard to some other countries in the Council of Europe as well. So hopefully some of these lessons learned that I will share will be helpful in that regard. But I will also make some more general remarks on the status of implementation, or rather non-implementation, in Azerbaijan as a broader systemic problem. Since we are the last panel today and people are probably getting tired, I thought I will let you know that I'll be following this rule of two. I will mention the two challenges that I wanted to flag, and also two lessons learned that I wanted to share with you. That being said, that doesn't mean that these are exhaustive, obviously. It's just that these are the two I decided to raise today. So two challenges. The first challenge that I think we all have to have in mind when discussing implementation or non-implementation of Azerbaijan is that there is a deep systemic absence of genuine political willingness to abide by the Convention rights and the European Court judgments. Statistically, some of you may know Azerbaijan is the worst implementer among all member states, in that it has the lowest percentage of its cases closed by the Committee of Ministers as fully implemented. According to the ECtHR database, today 90% of Azerbaijani leading judgments remain pending implementation. And in numbers, it means that only 6 leading judgments have been closed since Azerbaijan's membership of 20 years today in the Council of Europe. And among all those 6 leading judgments, there is not a single case where a closed case concerned implementation of general measures, which in other words means that there isn't a single case so far against Azerbaijan that has been closed where the committee would have considered that the authorities have taken sufficient actions in terms of general measures, or in other words, addressing systemic structural issues to close a case. So that's just one thing that we need to have in mind when dealing with the issue of implementation in Azerbaijan. And the second challenge is the absolute non-existence of transparency as to what plans or measures the Azerbaijani authorities have put in place to implement ECtHR judgments domestically. Today, not a single Azerbaijani citizen can access any information in Azerbaijani language on any official websites to find out what is happening with a chosen, say, judgment of a European court against Azerbaijan. There is no dialogue whatsoever between the civil society, or Azerbaijani civil society in particular, or lawyers or applicants and their domestic authorities apart perhaps from the issue of payment of compensation, where there is a certain procedure, rather informal procedure established where applicants have a possibility to contact the government agent's office on this issue. In my 10 years experience working on Azerbaijan, I think I never heard of a single meeting or any other engagement that an Azerbaijani civil society member or lawyer or an applicant, well, it's perhaps an applicant when general measures are concerned, but more civil society would have with the authorities to discuss what should be done with regard to implementation of specific European Court judgments. So really the ECtHR database is the only channel for information for them on those judgments. So these would be the two challenges that I wanted to mention. And now, against this very difficult background, there are still some strategies, I think, or some lessons learned with this idea of identifying some positive developments where some traction can be made that I wanted to share. And one of them concerns individual victims who experience grave violations of their fundamental rights. And then the second one would be more generally as to what could and should be done with such a systemic non-implementation of European Court judgments and what's working to some extent. So what we have seen in our work on the cases of human rights defenders and where we represent individuals and where we've primarily been focusing our advocacy on pushing for individual measures, such as, besides the payment of compensation, would be the reopening of domestic proceedings so that the criminal convictions that they were handed down during the crackdown would be quashed, meaning that there would be no trace of their criminal records following European Court judgments. And so on that individual level, and I speak, as I said, I speak about measures that go beyond the payment of compensation. Some traction is possible, dependent on whether there is a combination of two things. First thing is a very regular, consistent pressure from the Committee of Ministers and the civil society. And secondly, whether there is a certain political window which can pop up at a certain time for some positive developments. We have seen this in the case of our applicant, Azerbaijani human rights defender Rasul Jafarov, whose criminal conviction eventually was quashed on the basis of the European Court judgment. Alongside that of an opposition politician, Ilgar Mammadov, something that the Committee of Ministers and the applicants and their representatives have been calling for a long time. Whereas then other applicants, including Anar himself, if I'm not mistaken, however, have not had their convictions quashed yet. Where their cases are very similar in facts, and there is really no justifiable basis to not have those convictions quashed. And so I think this only indicates how selective the authorities' approach is to its obligations stemming from the European Court judgments. And now my second lesson learned, and that will be my last point right now, is on a more general level, and that is to say that the international arena is the only space for the civil society to engage with the authorities and learn, as I was saying before, learn about not only what is happening, but also to learn what their position is towards the case, what they are willing to do or what they are not willing to do. And that's so that the civil society could try to build their strategy as to a specific judgment. And what we observe is that the authorities' engagement on the cases is much more present with a CM supervision system, is where there is some, as I call it, nagging or chasing policy done. And Rule 9 submissions by applicants and the civil society are among those, because it really effectively activates the process before the CM, before the Committee of Ministers. For example, in leading cases under standard supervision, meaning that the level of scrutiny is much lower, there is very little information, if any, provided by authorities. I looked into quite many, if not all, of such cases against Azerbaijan, and I found that in at least 60% of such cases, leading cases under enhanced supervision, no information whatsoever was provided by the authorities. Not a single action plan has been provided in these cases, and the information on the remaining cases is limited to brief updates as to payment of compensation or any other rather important but still insufficient developments, such as translation of judgments and dissemination of those judgments among relevant bodies. And among those, there are leading cases where no action plans or reports have been submitted for over 10 years, for example, and it is possible to make that analysis that there is some traction where the CM scrutiny is much, much higher, is because there are a number of Azerbaijani cases where this has been observed, and where that scrutiny was much lower, then it becomes very obvious that the genuine willingness to engage with the process or abide by the rules of the Committee of Ministers, the rules of the game, is not there. So I'll stop here, and later on I'll share some recommendations as to what still could be done.
Great, thank you very much indeed, Ramute. I'm going to move us straight on, and I'm going to let's lighten the mood and talk about Russia, shall we? We have two NGOs here, Memorial and ERAC, who've been working on litigation from Russia, and particularly from Chechnya for the last 20 years. And let's start with Elba, and then we'll go to Dimitri at the national level, Elba at the international level. The work that ERAC and you've done, Elba, in recent years in exploring new ways of engaging at the international level, particularly in relation to enforced disappearances and other cases in the North Caucasus. Maybe you could say something about that, about the challenges and the strategies.
Thank you, Phil. So in terms of, by way of background, the enforced disappearance cases that ERAC has been working on alongside Memorial and other partners in Russia and Chechnya more specifically, this is a group of approximately 650 victims who were disappeared by Russian forces in Chechnya and surrounding regions between 1999 and 2006, although the disappearances continued past 2006. These are judgments that have been rendered by the European Court of Human Rights. The earliest judgments were in 2006, so that's approximately 16 years ago. In almost all cases, the court found violations of Article 2, 3, 5, and 13. They've been under supervision by the Committee of Ministers for over a decade now. It's always been difficult, I think, to look at positive outcomes from the implementation of these cases by any given measure. The process for execution of judgments of the European Court has failed these victims. But what I think is important to note is that the European Court did not fail the victims. And through conversations with applicants, I think one of the things we heard was that those judgments were important to this group of applicants. And I just wanted to raise that because it's been a really long day and we're talking about Russia and we're talking about enforced disappearances that happened 2 decades ago. So while the judgment itself brought a sense of acceptance of the truth and a small sense of accountability to the relatives, the implementation has not brought them what we realize they want the most, which is to have their loved ones home, whether it's their remains for a burial. And in that context, I think some of the challenges to implementation, which are reflected in what's been said so far today, and particularly by this panel, are the complete lack of political will by Russia to implement European Court judgments, but also the specific lack of political will to implement judgments that pertain to human rights violations in Chechnya. And I think that's been a missing piece of this story, that there is a marginalization that these victims and their relatives have experienced that has also acted as a further barrier to implementation of these cases. And along with that, there's also ongoing oppression and fear, both for civil society, but also for relatives, which really bars any kind of sustained and effective advocacy at the domestic level. Other challenges are the kind of presumably historical nature of these disappearances. A lot of time has passed since the original abduction, and that poses practical challenges in terms of investigation and the search for the victims. But it also has, I think, impacted the level of optimism and energy directed towards these cases at many levels, including places like the UN and at times also the Committee of Ministers. And finally, in terms of our role as a human rights center submitting Rule 9s to the Committee of Ministers, responding to Russia's actions plans is complicated to say the least. These action plans are often very sporadic in detail. Sometimes they're, inconsistent, and in many cases they pose a distraction, I think, to the systemic issues that exist in these cases. Those are just some of the challenges. I feel like we could just speak about challenges on this panel, so I'll stop there and I'll talk about some of the strategies that my colleagues at ERAC and I and our partners in Russia and Chechnya have been working on to try and overcome these challenges, and also try and outline some small positive steps. And I, as I say that, I recognize that this is probably the furthest. Today is the furthest that these families will get from finding out what happened to their loved ones. As we know, it's quite a dark day in terms of implementation of these judgments. The first strategy that we've applied is to engage applicants. I think applicants play such a huge role throughout the litigation process. It's their stories that are being told. They're extremely engaged in bringing the case to the court. And then in some contexts, they kind of disappear from the scene. There's a practical reason for that. I think in this group of cases, there's 650 victims. That means more than 650 applicants, disappeared victims, and the applicants involved, their relatives as well. And it is just hard for human rights organizations to sustain contact with the applicants. But I would say that we found that it's essential. We went back to applicants in 2016 and then again starting last year to check in with them. And that gave us a sense of what's been going on with them over these years. And it helped us figure out how to reframe our advocacy around these cases. In particular, it helped, the quotes that we received from applicants helped us in showing the urgency for these cases. I mean, in most contexts, the applicants are parents of the disappeared victims, some who have died and others who are aging. And what we heard from them is the daily anguish that they live in, not knowing what happened to their loved ones. And so something that we started to do is reframe our advocacy more strongly towards ongoing violation of their rights, particularly prohibition against ill treatment and arguably torture. It also helped us engage EIN through that type of reframing to say that this is an ongoing violation against this community of applicants. We also found out that there are maybe what I'd call tangential human rights violations that have stemmed from their experiences of decades of failure to investigate and bring to justice the perpetrators of these crimes, and also to return the remains of their relatives to them. They relate to social, financial, economic marginalization, gender-based discrimination and violence. There's important children's rights and elderly rights that are being impacted. And that drew kind of a broader picture for us of what the needs of these applicants are. And we use that in developing the second element of the strategy that I wanted to talk about, which is to engage more diverse international institutions. So we started to ask, which institutions, whether regional or international, have been referring to these cases and which haven't, and which ones does Russia engage and which ones does Russia respond to. And we found through that assessment that, as an example, at the UN, Russia has had country visit requests from a number of special procedures, including special procedures relating to torture, the Working Group on Enforcer and Voluntary Disappearances. But who they have allowed country visits from are special procedures like those working on gender-based violence, children's rights, and the judiciary. So we thought, well, we know that the experiences of these applicants relate to the mandates of these special procedures, so let's start engaging them. We also looked at who has expertise that is maybe lacking in the understanding of how these cases need to be dealt with. And so we started to work with the UN Working Group on Enforcer and Voluntary Disappearances, who have very much led the way in terms of developing standards for the search of victims. And through our aims in engaging the UN were, first of all, to find these points of contact, these alternative kind of people and structures that were maybe able to explore new pathways for sharing the urgency of humanitarian resolution, the search for the victims in these cases. But it was also to try and increase collaboration between the UN and the Council of Europe. So we pushed both the Council of Europe and the UN to engage in a discourse around how they would approach these types of cases and what could be done at this stage to push Russia. The third approach, how am I doing on time? Do I have a few more minutes? Okay, great. The third approach that I wanted to talk a bit about is the necessity to tackle technical questions and uncertainties even when there is a lack of political will. So for many years, Russia submitted action plans where it identified challenges to searching for victims that were at best inconsistent and arguably scientifically inaccurate. And we debated, I think, for a while whether we wanted to kind of look into some of these inconsistencies, because ultimately the broader issue was the lack of political will. But we decided that we would, and what we did is that we contracted a number of forensic experts from Durham University to write a forensic expert report responding to Russia's specific, we gathered together as much as we could and grouped the challenges that Russia had posed in terms of searching for victims. And these forensic experts responded to each challenge, and they found definitively that the scientific barriers that Russia had identified to searching for the victims, which refer to the dated nature of these disappearances and so on, were just not substantiated, and that there's forensic methods for searching for victims that would quite easily facilitate the search for the victims that were disappeared between 1999 and 2006. The forensic expert report also built out a framework for an ad hoc humanitarian search body, and it looked at what would be needed for this search body to be pulled together. And we have used that framework since 2019 to consistently call on the Committee of Ministers to essentially engage in a conversation of what a humanitarian search body could look like in the context of searching for the victims from these cases. And in terms of a win, in the most recent decision of the Committee of Ministers, they called on the Secretariat to do exactly that, to develop a document for looking at models for an ad hoc humanitarian search body. And I'll say that, of course, with Russia leaving the Council of Europe, we're not sure what meaning in practical terms this will have today for these victims, but we're really looking at this advocacy on this group of cases as a long-term approach. And that means starting to think now about, if there is, as Ramuta said, an opportunity to push for some progress, if there is greater political will to search for these victims, we want to be prepared with the resolutions and be able to actually offer practical solutions. Yeah. And then the final approach that I wanted to talk about is last year we held a series of international workshops. Is this still on? Yeah. Where we invited family members who had become human rights defenders, experts, academics, human rights defenders from other regions around the world who had dealt with the phenomena of enforced disappearances, including Argentina, Lebanon, Mexico, and who are in a different stage of the trajectory of seeking truth and justice for the victims. And we learned from them, and we had quite honest and open discourse around what was possible in contexts where there is widespread fear and civil society suppression. And there were really interesting learnings that came out of that. One of them being that as I said, you have to think long-term, and the other one being the importance of relatives participating and regularly engaging in advocacy at the domestic level, whatever that looks like, and it could look differently for different contexts where there is greater risk. I'll stop here. Those were just some of the strategies we used, and pass it back to you, Phil.
Elba, thanks so much. Let's go straight on to Dimitri, and maybe Dimitri, you could pick up the point that Elba just mentioned about domestic implementation. How is that looking in Russia in your experience? I think something that a lot of people in the room won't know a lot about. And maybe also you could then go on and talk, given Russia's expulsion, talk about implementation at the international level post-expulsion. You know, is that something you think should be pursued? Thanks, Dimitri.
Thank you, Philip, and hi everyone, and thanks a lot to the organizers for the opportunity to be here today to share my thoughts and to benefit from your expertise. And yeah, I think that one of the worst things actually continuing from where Elba has stopped is that history tends to repeat itself, and we actually see it right now. And I mean that the cases that were unresolved for so many years, now they are kind of repeating the same pattern, and that's what actually Memorial has stated on many occasions, that this pattern would be repeated, and now we see what we see. I mean, I apologize for the absence of clear structure for my presentation and for the lack of illustrations. I mean, that is partly because of there is no remade template when you speak about Russia, and it's hard to approach these issues, especially these days. I would say that after the Russian authorities literally went on a rampage in February, our capabilities as the civil society actors, they reduced dramatically in terms of human rights protection, in terms of protection, and in particular through the mechanism of the European Convention, of course, but also in terms of the way in which we can use the domestic mechanism and domestic ways to protect human rights in Russia. So as we all know, probably, Russia has closed itself and has been partly cut off any external legal assessment, I would say. And the Russian government, they have basically declared what I would call a default on their obligations under the international human rights law, and a default on conscience in general. The government, one of the major problems right now for the Russian civil society is that the government had enacted a wide variety of punitive laws and implemented a wide range of restrictive measures aimed at suppressing any dissent, any plurality of views, and even a mere criticism of the actions of the authorities or their mission. This undermines, of course, our opportunities for challenging effectively their actions and their decisions and their measures at the domestic level and through the domestic mechanism. I would say that, for the last 25 years, the convention, at least to some extent, served as sort of a restraining factor for the domestic authorities in Russia, but now the political leadership in Russia, they are doing their best to eradicate the convention at all from the legal system and mentioning of it, and to discredit the conventional values in the public eye inside the country. But at the same time, in the absence of a forum for continuing multi-level dialogue with the Russian authorities, it is very difficult for us to understand and to discern their position on sometimes very technical but very important issues of how actually the judgments of the court, for example, can be implemented, how the standards of the European Convention can be still applied, or whether they can be applied at all in the domestic legal system, because they basically keep silent on that. And more or less in terms of political authorities now, they lead this sort of one-way monologue through the legislative process. So we can hardly understand, but we're trying to understand their position through newly enacted laws. Somehow they verbalize this position in parliament records and in explanatory materials of draft laws. And here I would say that the formalistic and legalistic approach of the Russian government, their obsession with putting everything in the form of law, and the hyperactivity, I would say, of the Russian legislator, it actually, all these things, they actually play to our advantage. They allow us to sort of track the chronology of everything which is happening right now, and the development, the actual development of this monstrous logic, and to see the main milestones. In other words, their legislative process right now in Russia is sort of, I would say, a diary of confessions, meticulously kept and signed by the culprit himself. And it actually serves against him, yes, because it can be used against him and as a crucial evidence. On the other hand, the problem which we are now, I would say, face is that we still do not have a consolidated position of judiciary on what is happening between Russia on the one hand and the European Convention on the other hand, if actually this position, this consolidated position, can exist as such. Courts, they more or less try to keep silent on the issue of the authorities' obligation under the convention following the Russian expulsion from the council. For the past 24, 25 years, the implementation of the convention and its standards, it wasn't fruitless at all in Russia. But I mean, of course, it was mostly superficial. It was mostly decorative, I would say, and quite often it did not go beyond declarative provisions of law or general recommendations of the Supreme Court or the Constitutional Court. These superior courts in Russia, they regularly refer to the convention principles and convention standards and to the case law of the European Court, but quite often, instead of shaping the actual jurisprudence of the lower courts, they instead acted as a sort of a filter which wouldn't allow the convention standards to go deeper, to go into the very fabric of day-to-day jurisprudence of the domestic courts and the executive authorities, of course. We saw, of course, sporadic exceptions over the years at the lower level of judicial system in the decisions sometimes of the first instance courts, and which would be usually delivered by younger judges, younger generation of judges who just started their career in most far-reached regions of Russia. But the more painful it was to see that these judgments in which the convention would be directly applied, they were afterwards quashed normally by the appeal instances, and that's how they usually ended up. Here we should probably mention also speaking about judiciary, and we probably should also mention the health program of the Council of Europe, which has only started normally to work in Russia, I would say, from 2020, and it covered a growing audience of judges and lawyers, and of course this project required much more time to actually give some fruits. But I also have to admit, and probably we all, that there were huge missed or unrealized opportunities of continuing dialogue between the Council of Europe and the Russian authorities, and huge missed opportunities in terms of their direct interaction, especially in the recent years. And of course, I should also mention some instances of when the human rights violations were, so to say, forgiven by the Committee of Ministers or by the court, speaking about, I don't know, prisoners' voting rights or conditions of detention, for example. On the other hand, for example, compensatory remedies, first of all, designed for the length of proceeding cases and civil non-enforcement complaints, became sort of a success story of the implementation process in Russia. And so I would say has the entire court system in general, especially if we are talking about commercial proceedings in Russia and about, so to say, neutral civil and criminal cases which were devoid of human rights conflict or political element. Because in these cases, the system demonstrated that it can be actually swift, it can be transparent, and can be more or less user-friendly in terms of people, in terms of parties which entered these proceedings. And quite surprisingly, we saw that even in the proceedings on the dissolution of Memorial, because we had basically no obstacles in terms of access to court and in terms of monitoring the progress or regress of our cases. Yeah, but another and more important problem is that the final product of this system, the decision-making process, the predetermined nature of the court's judgment, a lack of judicial independence on the issues and in the key areas where we exactly needed impartial and independent domestic courts to intervene. That's the actual problem of content of this system, I would say. So our current task, I would say, as the actors of civil society is in Russia, is to record, first of all, is to record thoroughly human rights violations and to keep this record of, I would say, the decay of legal values in Russia. And that is why we extensively use the accessibility of the judicial system in Russia to our advantage as far as we can. For example, Russian opposition politics like Navalny or Karamurza, they use these endless trials against them like as a platform, as a tribune to broadcast their ideas, their views and their political agenda. And more or less the same thing was done by Memorial actually, and by Memorial lawyers who continue to raise, and even now, and I would say uncomfortable questions before the domestic courts, and at the same time no longer aiming for persuading the courts and for obtaining justice, but mostly to lose yet another case, but at the same time making the superior courts acknowledge in writing yet another violation against the basic legal values. So and to make courts actually explain in details this new kind of legal order of, in Russia, and to explain how actually it functions in their view. Of course, we also hope that by raising these uncomfortable questions before the courts at the domestic level, we can still provoke sort of a crack within the monolith of this absolutist system, and the crack which can in the end lead to the actual separation of powers between the judiciary on the one hand and executive authorities or major political powers on another hand. And if certain courts, I mean, or judges would suddenly disagree with the superior will of one man and would follow probably at some point the spirit of law and the legal values of which Russia has been a part for almost 25 years, at least formally. And that's exactly, in my view, is important, for example, to get an opinion of the Constitutional Court on the recently enacted law concerning non-execution of the court's judgment, because so far Constitutional Court has remained silent on it, and at least we are going to obtain by this way one more confession from the offender and one more clarification. So yeah, to finish, I would say that closed systems in generally, they are inviolable, and Russia now has set a course toward the closure of its legal system. And it is understandable that in the face of the Russian aggression against Ukraine, international community, or at least large part of its side, I would say, in relief, when the dialogue with Russia was discontinued. I will leave aside the issue of legality of the Russian expulsion from the Council of Europe, because here I would say that I share not so popular opinion that the actual procedure in terms of its compliance with Articles 7 and 8 of the Statute of the Council of Europe was not actually observed. But still, what is important in this context, that the Russian civil society has lost an important external body, which could not not only accept the information about human rights violation, not only process it, but also give an independent, impartial legal classification and legal assessment to this fact, and in fact, which was able to deliver binding judicial decisions. And this loss, of course, is acutely felt and would be felt by the legal society in Russia. And despite Russia's leaving the jurisdiction of the European Court, at least at some point after September, despite being covered in this fog of war and injustice, this information about human rights violation in Russia, which now have reached an enormous scale, and they would grow even larger, must have some sort of an external regular assessment, legal assessment. The vacuum and the lack of this external court for Russia should be somehow replenished, and these solutions should be found. And because of the dramatic deterioration of the human rights situation in Russia, it would unavoidably affect the European continent in general. And because I would say the failure of the civil society in Russia, it is a very important lesson for the colleagues and for people in general in other countries. And I hope that our experience of our efforts, experience of our successes, occasional, and of course experience of our losses, it should not be in vain. Thank you.
Dimitri, is that working?
Not sure.
I don't think it's working. Dimitri, thank you. Just briefly, are you still advocating engaging with the Committee of Ministers on the implementation of Russian judgments? Is that, or do you think that's something that, what's your view on that now, just briefly?
Yeah, I mean, it's not about actual effectiveness or fruitlessness of these actions anymore. It's about what has to be done in terms of, I would say, of and because in part of our stubbornness. That's it. So yeah, we still continue this. We would continue, and we are continuing now these efforts because it just must be done, first of all. And the second thing, because we cannot consent to the laws recently enacted by the Russian authorities, and we cannot accept that these laws stand as a genuine and truly legal act. So, well, more or less, in our point of view, they should be completely ignored. But the fact is that they are there, and they are there to create an impression of some sort of legal basis for the Russian authorities not to comply with their obligations and not to fulfill them. But still, this work has to be done, and we still have to advocate and and push forward.
Thank you very much, Dimitri. Let's go straight to Turkey and Kerem, and maybe Kerem, you could pick up one of the issues that Dimitri's talked about, is the role of national courts. We know how fundamental that is. What's your view of the role of national courts in Turkey, particularly the Constitutional Court has taken? And maybe you could also say something about the work that civil society has been doing, again, at the Committee of Ministers level and Rule 9s and so on, and whether you think that's effective or could be more effective. Thanks.
Thank you, Philip. These authoritarian governments have a lot of common stuff, but of course they differ on strategies that they adopt. So Turkey has a relatively good implementation record comparing to Russia and Azerbaijan. There's a reason for that. Turkey tries to give an impression that it's a convention-compliant country, and it really invests a lot. I don't know whether you have seen the huge permanent representation of the Turkish government in Strasbourg. It might be one of the biggest public buildings in the city. The reason is that Turkey is investing to human rights. It might sound surprising, but of course not in the way you understand, to persuade that it doesn't commit human rights violations. So it really spends a lot. So our friends in EIN knows, and they keep informing us about the new action plans, action reports of the Turkish government in different cases, not just in leading cases. They keep informing the Committee of Ministers in standard supervision cases as well, just to get some cases closed, to say that, okay, we achieved, I mean, we closed that number of cases. So this is a very different strategy, I guess. And Turkish Constitutional Court is at the heart of this strategy, because there's a consensus about dependence of judiciary in Turkey, but one exception, Constitutional Court. Everyone says that, okay, we know that there's no independent, impartial judiciary in Turkey, but the Constitutional Court. This is the success of the Turkish government, because 12 members out of 15 in Constitutional Court are directly appointed by the president. At least other judges and prosecutors are appointed by other bodies, not directly by the president, but 12 members are directly appointed by the president. And 3 recent appointments show who are being appointed to the Constitutional Court. 2 deputy Minister of Justice and 1 chief prosecutor of Istanbul, who was in power when the indictment against Osman Kavala was prepared. So, I mean, when they appoint the right people to the position. But still, why the Constitutional Court is that credible? Because even with the existence of the Constitutional Court, there are 15,000 cases pending before the European Court against Turkey. With the departure of Russia, Turkey has become the biggest client. And I guess even if it didn't leave the club, Turkey would be a candidate as the leading country. And 100,000 other cases are pending before the Turkish Constitutional Court. We are not expecting all of them to reach Strasbourg, but even if 10% of all those cases pending before the Constitutional Court are brought to the Strasbourg Court, it makes like 1/5, 1/6 of the whole cases pending before the court. That's why the Constitutional Court is critical both for the European Court and for the Turkish government's strategy. But it's the main challenge for the human rights defenders and the lawyers, not just about its role blocking the way to Strasbourg, but also about non-implementation. It's the main actor of the non-implementation of cases decided against Turkey. I will give some examples about this. In 2013, in Hasan Uzun versus Turkey case, for the first time, the European Court recognized the Turkish Constitutional Court complaint mechanism as an effective remedy to be exhausted. In that judgment, the court said that it reserved the right to examine the consistency of the Constitutional Court case law with its own. But ever since then, there has been no exception to the rule. You have to exhaust local remedies, even if it takes ages to exhaust the Constitutional Court. 4 critical examples, 2 individual applications and 2 general measures. All of them are very well known. The first one is Osman Kavala versus Turkey. The very first Article 18 judgment delivered against Turkey, as you know, is now back again before the European Court of Human Rights under infringement proceedings. This case was decided by the court on 10 December 2019, and Mr. Kavala was released in the case after that judgment. But he was detained back with the same evidence, but under different charges. And this second case was brought to the Constitutional Court, and the court decided opposite to the European Court's decisions and didn't find a violation of Article 19 and Article 19, paragraph 3 and Article 19, paragraph 7 of the Turkish Constitution. The Committee of Ministers later found that the Constitutional Court's recent ruling finding the applicant's current detention lawful is based on the same evidence examined or referred to by the European Court. So this is the first strategy of the Constitutional Court. It's a clear strategy. Do not apply what the European Court said, but this is not the only one. The second one, the strategy, is delaying domestic proceedings. It's in the Selahattin Demirtas case. As you might know, Selahattin Demirtas won his case before the Grand Chamber, and it's the second Article 18 judgment delivered against Turkey. In that case, the court, for the first time, used the term return to pretrial detention. What it meant is that Turkey claims that there's a new investigation, there's a new prosecution against that person, that's why he's under pretrial detention. But the court thinks that this is the same, because the first and the second detention are based on very same evidence. But this time, unlike what happened in Osman Kavala case, the court decided not to decide. So his lawyers, Mr. Demirtas' lawyers, applied to the Constitutional Court on November 2019. And ever since then, we are waiting the Turkish Constitutional Court to decide on this case. Because of the Mehmet Hasan Uzun decision, the European Court does not decide on that case either. It was communicated. So the government replied, and the applicant's lawyers submitted their observations, but the case is pending before the European Court of Human Rights. And the Committee of Ministers, in its most recent decision, said that, in that regard, regretted that no date has yet been indicated for the determination by the Constitutional Court of the applicant's complaint concerning his detention lodged on 7 November 2019. So the Constitutional Court doesn't decide, the European Court doesn't decide, Committee of Ministers cannot decide or comment on the judicial proceedings against Mr. Demirtas. When it comes to general measures, we see a similar pattern, but again, different strategies. The first thing is strategies ignoring the Strasbourg jurisprudence. It's about insults to president cases. As of end of 2020, there were 160,169 criminal investigations brought under this provision, and about 38,000 people were prosecuted. This figure should be now around 50,000 prosecution, 200,000 investigations. In an earlier case, Artun Güvener and others, the European Court already held that a provision which gives a privilege to the head of state is in conflict with the spirit of the convention, so against the convention, so it can't be implemented. But recently, in Vedat Şorlu versus Turkey, the court gave a semi-pilot judgment using Article 46 of the convention, and it indicated that there is a systematic problem about those cases. But even after that, the Turkish Constitutional Court continues to ignore the whole jurisprudence of the court on insult to heads of states, not only about the cases brought against Turkey, but also cases brought against Spain and France. This is important because generally in individual application proceedings, the Turkish Constitutional Court cites the jurisprudence of the European Court of Human Rights. But when it comes to the insult to president, suddenly it forgets entire jurisprudence about insult to president. So another one, this time the Constitutional Court decided that the European Court made a wrong decision. This is about the detention of judges and prosecutors. In a series of cases, started with Alparslan Altan versus Turkey and ended with Turan and others versus Turkey. But when I say others, 429 others. So in total, 430 people were detained with a similar procedure. As in any other member states, judges and prosecutors have immunity under Turkish law. But all of them were detained without their immunity was removed. And how did it happen? The Turkish authorities stated that they were caught hot-handed while committing a crime, because the government claimed that they were accused of being members of a terrorist organization, and it's a continuing crime. When you catch a person while committing a crime, you don't need to remove that person's immunity. All of those judges and prosecutors were committing a crime at the time. And the European Court stated that the concept of flagrante delicto cannot be expanded in this way, because it's unforeseeable if you interpret in this way. This case was re-examined. I'm about finished. This is the last example. The Turkish Criminal Court said that this is about domestic law. You cannot reinterpret, the European Court cannot reinterpret the national law. And I'm coming to the positive thing that we have done as civil society organizations. Two important examples: International Commission of Jurists, Human Rights Watch, and Turkish Litigation Support Project kept informing the Committee of Ministers about the developments in the cases of Kavala and Demirtaş. And it really gave the right information to the committee and affected the decisions taken by the Committee of Ministers. I'm not going into the details, but I think, we can discuss later if you want me to elaborate on this. A second example is about the statistics. Turkish government submits interesting statistics to the Committee of Ministers. It picks this, picks that, but do not reflect the entire picture to the Committee of Ministers. And with freedom of expression association, we kept informing the committee about the real statistics and requested the committee to ask Turkish government to provide the full statistics about insult to president or other similar criminal cases. And that blocked the Committee of Ministers' decision to close premature cases. And it asked to the Turkish government to provide information. This is very critical because as a human rights defender, you can communicate with the Turkish authorities only before courts in Turkey, charged with some serious crimes. So it's a proxy way to communicate with the government through Committee of Ministers, because as the strategy of the government is to inform the Committee of Ministers, they reply. That's why we can get in communication with the government through Committee of Ministers. We write to the Committee of Ministers. If you write domestically to the Turkish authorities, you receive no answer. But if you write to the Committee of Ministers, they reply. They reply to the Committee of Ministers, but in an indirect way, they also reply civil society organizations. I think this is the positive thing that we can derive from Turkish experience.
Karim, thank you very much indeed. I want to ask the others in a few moments about their recommendations, but I want to actually, I'm going to go to the floor, go back to you first. Let's open for questions and discussions, and then we'll come back. Anna, are you still with us? Can't see you. Anna's still there, great. So we'll have questions, comments from the floor. Please, as ever, do introduce yourselves. If you can be reasonably concise, that would be great. Who would like to kick us off? Alice at the front here. Thanks, Alice.
Very quick question. We've talked a little bit today, or the idea has been floated of sanctions somewhere, something more than an interim resolution, possibly less than infringement procedure, or maybe that it would be a reconceptualization of the infringement procedure to not be something that's only used on very occasional basis. So I just wondered if you had any thoughts about what such sanctions might be. I don't want to preempt the recommendations you were going to make, but that's been something that's sort of floated around the discussion all day, and obviously is particularly apposite to the states that we're talking about here. So any thoughts you have on the design of smart sanctions that might exert leverage?
Thanks, Alice. Let's take a couple more, and then we can come to the panel as a whole. And Anna, we'll come to you on sanctions amongst other people. Any other questions at the moment or comments? If not, we'll go to Anna on sanctions. Do you have a view on that in response to Alice?
Okay, thank you. Yeah, sanction is also the general topic in Azerbaijan among human rights lawyers and civil society groups. So, but I'm wondering regarding the sanction policy of the Committee of Ministers, the Council of Europe. So we discussed several times this kind of the topic. So problem is that I think there is a need for diversification of the sanction policy of the Committee of Ministers, the Council of Europe, for non-implementation of the court judgments in challenging status, including Azerbaijan, for example. And there is a need to adoption more concrete and strong measures for this purpose. So, unfortunately, it is not clear the position of the Committee of Ministers with challenging states. So, one hand, they accepting all communication or intervention from civil society groups. Sometimes, very rarely, they visit the country and to meet with the people. But unfortunately, this kind of meeting is not full participation of the all stakeholders. Or, for example, it is not clear for me that 3 days ago, the office of the Council of Europe in Azerbaijan, with the Bar Association of Azerbaijan, organized the event on implementation of the European Convention in Azerbaijan. But the representatives of the conference, the participants, were only members of the Bar Association, and among them there are no independent lawyers, no civil society groups, no other the interesting stakeholders. But group of people visited from Strasbourg, and they participated, attending this conference, and they talk about Azerbaijan, for example, positive, significant, some scores, some records. So this is not clear for us that Azerbaijan is among challenged states in terms of the implementation of the European court decision. But one hand, there is the group of people coming and attending, and it looks me, for example, Mr. Altinparmak already mentioned about to pursue the international communities that there is the presence of Azerbaijan in this European club. However, Azerbaijan already ignored this kind of the calls and the implementation of the European Court of Human Rights decision. So Azerbaijan already ignored all calls adopted by Committee of Ministers. So this is not clear, and I think there should be some sanction mechanism and clear and also diversification of the sanction policy is important right now for Committee of Ministers. Thank you.
Thank you, Anna. Dimitri, smart sanctions?
I'm not so smart to talk about them. Yeah, but I wish to refer very briefly to what Madame Meyer said earlier this day about, that we actually have the documents concerning, at least working documents concerning concerning this sanction system. My rather pessimistic view would be that sanctions, any sanctions, smart sanctions or not so smart sanctions, that they would be effective even only if we speak about, some kind of negligent attitude or occasional failures. But if there is no actual political will and a genuine desire to adhere to these particular values, then no sanctions actually would be effective. So, I mean.
I would suppose to impose fines because, media like exaggeration. So, for instance, when a decision decided against Turkey, the small alternative opposition media said they found Turkey guilty. So they use this, and then they say they impose that money to be paid to the applicants. So, you see that some kind of guilt and responsibility when it is said like that. So if a general measure is not implemented for a certain period, there might be some fines for a year, for 3 years, for 5 years, and not the amount of money, but the symbolic meaning of this and how it is transferred to media might be critical to persuade governments to work more on implementing the judgments. I don't know where that money can go. It might be used to improve the standards of the court, for instance. That will be good, or the capacity to improve the capacity of the court. But imposing fines might be a good idea as an alternative sanction.
Thank you, Kerem. More questions, comments? Başak.
Thank you. I just wanted to make this observation because some of the things, Kerem, you were saying, we have different experiences, but there are also commonalities. And something that came as a commonality is how important the Committee of Ministers process is for getting information, communicating with the authorities, keeping a record, a correct record, or correcting, and there was this trail of record keeping. I mean, some of these have come through as a very important thing. So all of a sudden, the Committee of Ministers is a completely different. It gives us a very different picture of what the Committee of Ministers' value is. And I do understand all of this, but is this because there's no other value to it? I mean, I just wanted to see, because I mean, these are important things. I understand that the process is there and that there are certain opportunities to engage with it. Are there also any shortcomings or difficulties, given that this is the most important platform for communication? And what recommendations would you have if this becomes a very different place all of a sudden, where you get information, dialogue? So how would you improve that? Given that it plays a very special, a very distinct role when you have no domestic communication, information, advocacy.
Rumute.
Thank you. Does it work? Yeah. Thank you, Başak, for this very important question. And although the Committee of Ministers, the international arena as such, plays the very significant and perhaps the only role important role in this, or creating that platform for engagement, I think the two recommendations that I had in mind primarily relate to that. So I'll share my recommendations in response to your question. And as I mentioned in my initial remarks, so the Committee of Ministers and the civil society play an important, significant role in terms of engaging as the Azerbaijani authorities with the process. However, the question then is how effective that engagement is. Or by engagement, I mean that they do reply to Rule 9. As Kerem was saying, in the Turkish case, they do reply. We do get replies and we get some substance there. Then the question is how sufficient, how relevant, how effective that content is. And I guess my brief answer would be it is not. It is not. Sometimes it's not relevant, sometimes it's not sufficient, but there is always a no around it. And so my first recommendation would be in relation to the cases of such a systematic non-implementation of judgments, as is the case with Azerbaijan, where we don't have a single case or group of cases that have been closed on the basis of general measures, as I said, or that some very genuine structural systemic changes have been made. I think this Committee of Ministers needs to change or to improve its approach to countries like that, and it needs to have a more robust and more active reaction to such a situation. And it could start with putting all the leading cases under the enhanced supervision, and in that case, ensuring a higher level scrutiny by the Committee of Ministers, because as I mentioned earlier, majority of the cases under the standard supervision there is no traction there at all. There was a mention of fines and sanctions. There is a need for a more robust reaction to this. And I'm not even only talking about those more politically sensitive cases as we know them, Article 18 cases of human rights defenders, for example, or the related cases. Let's look into this big group of cases that relate to ill treatment and torture of individuals imputable to law enforcement agents, for example. For almost 11 years until the first CM decision came in, there was not a single action plan or action report by the government. Now that this case is on the agenda from time to time, there is some engagement with the authorities. But then, and given the fact that the Council of Europe's own CPT has called this practice of ill treatment and torture endemic just a couple of years ago in Azerbaijan. So given that, having that in mind, is there really a point, or how effective is it to, for example, give another year for Azerbaijan to report on the progress to the Committee of Ministers, meaning that the authorities have another year to produce another action plan on what they are doing or what they're planning to do, really? So the question is really how efficient are the current means of engagement, the means of exchange, and I think that certainly needs to change. And my second and last point, a recommendation, relates to the civil society in Azerbaijan as an important and an important domestic actor which can provide alternative, genuine information as to what is happening on the ground. And my proposal concerns the pressing need to better equip the civil society to engage in this process. And this can be, I think, the civil society outside Azerbaijan is trying their best to support them. If you look, for example, at Rule 9s that concern general measures, so the reports that come from NGOs as opposed to individuals, majority of them are submitted by NGOs outside the country. They don't come from within the country. That does not mean they're not prepared in cooperation with the Azerbaijani human rights defenders and lawyers, but this is because partly it is not very clear for them, it is not too risky for them to sign a Rule 9, for example, because NGOs do not exist anymore the way they existed before the crackdown, and because of the current NGO legislation that Anar was talking about at the very beginning, which should be the starting point of the implementation journey. It is not very clear if it wouldn't even be legal to engage in such kind of activities as an NGO under the domestic law, not to mention the absence of any sufficient funding and existence of projects that would allow NGOs to run such activities on an institutional level. And I had a few ideas as to how this could be done, but this would, I think I'll just stop here. But just to summarize, my key recommendation to the Council of Europe, I guess more generally, would be to really think about how it can support its other important domestic actor, which is the Azerbaijani civil society, which has been effectively eradicated following the 2014 crackdown, and they haven't really got back to where they should be if they wanted to engage in the activities that we are engaging today, for example, coming from other countries of the Council of Europe. I'll stop here.
Thank you. Thank you. Thank you, Rumut. Elba, how would you respond to Bashek's question? And then we'll come to the last round of questions. Elba.
Yeah, I would say there are two other roles that I was thinking about when listening to your question. One of them is as a negotiator, and I think that can become quite useful in contexts like Russia a few years ago, perhaps, where you're working with, for example, this group of cases where there's a number of general measures that need to be implemented, but some are clearly more important than others. And perhaps there is a way to, get the state to move the dial slightly on some of the measures that it feels are less of a threat in a way, which in this case we were saying, for example, a humanitarian search body is something that if it could be used just for the search and not for the information gathered through it could not be used for accountability measures, Russia may actually, at some point be willing to consider putting together such a mechanism. And I think the Committee of Ministers, but in particular the Department of Execution of Judgments, can play a role in having these behind the scenes negotiations. And the other role I can play is to provide technical assistance. And I guess in particularly in the context of Russia, where these judgments are still under consideration by the Committee of Ministers, but Russia, as I understand it, has stopped engaging with the Committee of Ministers. As much as the information that the Committee of Ministers shares publicly is an opportunity to inform civil society on what's going on, I think it's civil society at this stage that's actually informing the Committee of Ministers in the absence of any state action plans. And a stronger civil society and a civil society that is able to actually continue to provide that information only strengthens the ability of the Committee of Ministers to do its work. So I would say that I think particularly the DEJ, but more broadly the Council of Europe, at this time vis-a-vis Russia could be thinking about how to assess the needs of civil society, whether that's technical assistance or otherwise, and try to develop frameworks within its remit of tools to try and support them to share some of this information.
Thanks, Elba. Last chance, and then we should close. Oh, you want to come in, Dimitri? Sorry, Dimitri's going to come in, and then we'll come to Aisha.
Thank you. Yeah, just very briefly a couple of words, because we speak a lot about sanctions, but yeah, that's exactly the point which you just mentioned, and perhaps from a different angle, but whatever. The main aspect which we should not overlook is actually persuasion, like an addition or an auxiliary element to the sanctioning and forcing someone to do something. We need also, and that's perhaps the important role of the Committee of Ministers and the Council of Europe in general. I mean, to persuade the key actors, kind of explain why exactly do they need why exactly do they need these values, why they should adhere to them, and planting, so to say, these seeds of the understanding and growing them afterwards with the new generation, perhaps, of lawyers, and it's a painful process and very it requires a lot of patience and time, of course. But the important thing is that human rights organizations such as the Council of Europe, it should constantly be there, like, constantly reminding why these values are important, how they should be implemented, and what is the actual gain from that, and why in the end it's going to help to the, I don't know, criminal justice system or judicial system in general, or to the executive authorities. So persuasion is a key element, I mean, in this kind of function. Yeah.
Thank you, Dimitri. The last question from Aisha. If there's another, got time for one more after that. But yeah, John at the front here. So we'll take those two, and then we'll finish. Thank you, Aisha.
Thanks so much. I'm a legal trainee at the European Court of Human Rights. I have 2 points to make, maybe questions or comments. One relates to a comparative view. Let's zoom out from the European region, and if there is any best practices or in other regions of the world, like, for example, Inter-American Commission or African Commission, how do they really implement their judgments? What is the procedure? I don't know exactly. But has there been any dialogue with, for example, human rights lawyers in Latin America? How they deal with this kind of situations, so that maybe we can have some best practices? And the second point is about if we turn to the basics of public international law, these member states has consented to the jurisdiction over the cases. That's why they are bound by the decisions. But how could civil society remind that this consent element, which is so essential in international law, probably when they ratified the European Convention, it was 1954, but now we are like after 70 years, how can we remind them that it was the consent that they gave that makes them legally binding? Thank you.
Thank you, Aisha. Let's just take John's point last of all. John, there's a microphone coming. And then thank you. Thanks, Agnes.
It was to Ramuta and Anar, but I think by extension it really applies to everyone. But specifically you two, I mean, what you described was so bad. I mean, it worse even than I can manage when I'm feeling at my most aggressive and destructive. You really struggled to identify a single thing that was working or positive, and even the thing you advanced was pretty apologetic. To flip the question the other way around, do you see there any harm in the continued presence of Azerbaijan in a system in which it ignores in almost every single respect, but still gets to say, I'm part of this club? And is that a meaningful balancing act that at a certain point one needs to engage in? If it's doing minimal benefit, is it at least doing no harm? I suppose is the question. It's not like Aliyev doesn't say,
Anna, let's direct that question to you to start with, if that's okay, Anna. Did you hear that one?
Okay, can you hear me? Yeah, very interesting question. Actually, I think it's harmful that being a member of the European family and also ignore all kind of calls for promotion human rights and rule of law. And also we remember the caviar diplomacy report which issued by European Stability Center several years ago. And I remember that I was part of the process when a member of the parliament, the German parliamentarian Strasbourg, prepared political prisoners report in 2013, and how this report by majority of the members of the Parliament Assembly of the Council of Europe rejected. So this kind of cases, unfortunately, in Azerbaijan, I'm representing civil society groups, the group in Azerbaijan. In our country, we accepted these kind of cases as a failure of the Council of Europe. Its mechanisms in terms of the protection of the political liberties, political rights in a single country. At the same time, I think it is somehow undermine legitimacy of the Council of Europe as an institution. It has a perfect the values, it has a perfect documents and perfect institution like a European Court of Human Rights. But if one country like Russia, Azerbaijan, or I don't know, Turkey, they for many years systematically, periodically, they ignore all calls and they don't implement the judgments. We have to think about some kind of the mechanism how to punish these countries. I don't know. I don't have an answer. I don't have an answer for punishment, but I think something should be adopted for these countries. Otherwise, it's harmful for internally for these institutions, and it undermines the legitimacy of these institutions in my country.
Just very briefly to add, is it working? In response to John's question, to add to what Anaya said, it's such a big question, and it's quite an old question already that we keep asking ourselves, and there is a reason for that. And I think for now, and we briefly touched upon this during our brief, short work cafe discussion, World Cafe discussion earlier, I guess my sort of initial reaction would be, I guess it depends whose perspective we are looking at. If you're looking at from the perspective of safeguarding the convention system, or the democratic club, which John, you were talking about, then we have one answer. But then if you look at the perspective of the individual victims who still see the court as this, as they call it, the only hope for justice, then I think we have a slightly different answer. So yeah, that would be my comment at this point.
Thank you. And Dimitri and Kerem, I think to respond to Aisha and Elba, the last few comments, and then we'll close. Dimitri, you go. Okay. So Elba and Kerem then. Elba.
Maybe I'll just respond to, well, not respond to John's question, but comment on John's question, which is to say, we've done quite a bit of research on the trajectory of uncovering the truth in contexts like Chechnya. And like I said earlier, spoken with community groups who are now working in a regime change context. And they stress quite significantly the work that was done when the regime was in place to track the human rights violations, even something as small as where there was no system for tracking who disappeared. It took something like 10 to 15 years to determine whether people were actually disappeared. So in terms of truth and justice in the long term, and maybe historical truth, we've heard that it's essential to do this work now, and that if there's a vacuum of time, that negatively impacts the ability to find the victims, but also to accurately record their stories.
A short comment about what Başak said. I think there's still room to improve about civil society's contribution to the implementation proceedings in Turkey. The number of Rule 9 submissions increased significantly in the couple of years, but still the leading human rights organizations like Human Rights Association, Human Rights Foundation of Turkey and others contribute very little to this process. There are a lot of reasons for that, but I think the main thing is how to bring what you say here to the domestic human rights activities. There should be a connection between the activities that are conducted in Turkey and before the Committee of Ministers. Both of them can breed each other to strengthen the quality of the work at Strasbourg and back in Turkey.
And Dimitri's going to respond to Aisha, I think.
Just a couple of thoughts. I don't think that I have the clear answer, but I understand that this system it should be an open system, and it's very important thing to actually to let the best practices in. And speaking, for example, about the Inter-American Court, well, it's interesting, and we should look at their experience. But I think that the major problem for, if we speak in terms of the functioning of the Council of Europe and the system of the European Convention, is the legal aspect and the legal ground and the priority of an individual application in terms of how it is provided in Article 34 and the difference in this aspect between, for example, the system of the European Convention and the system of Inter-American Court of Human Rights, where you basically have 20 judgments and everything else is execution. So here we have like sort of another aspect, more or less. Yeah. So that's
and Aisha, we can point you to a special issue of the Journal of Human Rights Practice from 2021, Alice, which was on implementation, and there's quite a lot of work on comparative, looking at especially the Inter-American system, which I think we have a lot to learn from. I'm going to close it there. We've overrun. We started a little bit late, so we've overrun a little bit late. You've all worked incredibly hard. I want to thank you all for all your participation and the comments and questions. Thank our panel very much for this final session. The great news is now you all deserve a big drink, and there is a big drink in 10 minutes' time. We have our reception downstairs starting at 6 o'clock. And a huge thank you to Agnes and the EIN team for a fabulous day. Thanks so much. We're back after reception, back here at 9 o'clock tomorrow. And let me just check that Başak or Agnes or George want to add anything before we close. Agnes, over to you.
Yeah, so the reception is not downstairs. There is a sauna if you want to go downstairs, and a fitness club, maybe for later. But it will be on the terrace and restaurant. Sorry? So it's just terrace. And yeah, we'll close the room. So I would suggest that you take your bags maybe. We'll close the room for the technical stuff, and we look forward to see you at the cocktail and tomorrow morning at 9 o'clock. Have a nice evening and good night.
And please join me in thanking the panel.